Superior formally asked all local governments to open registration for same-sex couples. It was after the said legislative or executive process that in Judicial Yuan Interpretation number 748, the Constitutional Court further expanded rights to allow formation of permanent unions to include same-sex couples. It started initially by legislature, then executive stepped in, and then the judgment, my lord, of...
now you have the law, I think, in 2019.
Yes, my lord.
And even in Austria, now let's see, because Austria was one case which was given, which is shown to us.
My lord, page 34, your lordship would get. My lord, the Chief Justice, 34 PDF. 34 is Austria.
Yes. Now, what is the position? Even there, it was
Yes.
followed by legislation.
Yes, my lord, legislature provided for registered partnership for same-sex couples in 2010. The relevant provision in section 3, my lord, translation, a registered partnership can only be founded by two people, registered partners. In this way, they form a long-term partnership with mutual rights and obligations. Role of court. In January 2013, the Constitutional Court ruled that the registered partnership law was partially unconstitutional, broadening the rights of registered partners. On 4th December 17, the Constitutional Court struck down the ban as unconstitutional, ruling that preventing same-sex couple from marrying violates the principle of equality and non-discrimination. Lord, there was a prohibition which came to be challenged. Lord, therefore, my lord, I started by saying...
As in the case of Windsor.
Yes.
As in Windsor also the prohibition was challenged.
Because there is, your lordships are not, my lord, confronted with a situation where there is a law prohibiting same-sex couple, my lord, marriage.
The UK was a situation where they first recognized by a law civil partnerships in 2006.
I think that
after 7 years later, they enacted the Marriage Act.
Yes.
UK is very interesting. You might read that.
You just see the UK, actually, your page item 32.
Yes, sir.
At PDF 45.
Yes, ma'am. I'll just...
Gaidan was 1999 or 2000.
Lord, Gaidan, my lord, was, my lord, cited out of context, my lord, and I have, my lord, given a detailed note on Gaidan in this.
Mr. Solicitor, just keep ourselves to this, because Gaidan was in some other context, one realizes. That was in the context of a tenancy where...
One, my lord, Rent Act was in question. That apart, even there is another, my lord, fundamental, foundational distinction, which, my lord, I'll come to, my lord. But please see item 32 by legislature. And Civil Partnership Act 2004 came into effect in December 2005.
Actually, in the context of a tenancy, the real principle is of settled residence. So the law gave protection to the surviving spouse of an erstwhile tenant. Why is that protection given? We also have it in our Gyan Devi Anand, that whole line of cases from the Constitution bench. The idea is that when a tenant dies, anybody who's in settled residence as a member of the family should also be entitled to the protection of tenancy, which is otherwise a heritable asset. That's the principle. Gaidan also said the same thing, that, well, if you have a same-sex couple, even though the statute doesn't recognize a same-sex surviving spouse, the principle they adopted was, the principle is really that of a settled residence. And the idea is to protect, as a matter of social welfare, one of the occupants of that particular tenancy, then that should not be deprived to a same-sex surviving spouse.
Your lordships are right. That was the fact. But, my lord, forgetting the fact, the principle which was relied upon was fundamentally flawed, my lord, and that's my separate argument. Why, my lord, Gaidan would not apply in the Indian context.
Just read now 32 at internal page 45.
32, my lord, I was at 32. United Kingdom, the Civil Partnership Act 2004 came into effect in December 2005. It created civil partnerships which gave same-sex couples who entered into them most of the rights and responsibilities of marriage. Thereafter, the Marriage Act 2013 for England and Wales.
Mr. Solicitor, this act, you described it in a very classical form, but actually that resulted in amendment to a lot of other enactments in 2004 itself.
Yes, my lord, your lordships would find that at PDF 549. My lord, volume 5 of our compilation, PDF page 549. 2013 Act, my lords, we have placed them on record. Place that act on record. That is marriage within bracket same-sex couples bracket over Act 2013.
So that resulted in an amendment to various and other enactments.
And
That
then
is
two-
also,
and
my
then
lord,
2013 led to a series of amendments thereafter.
correct, my lord. That is also, my lord, part of that, my lord. I'll come to that, my lord, after showing this. Because right now this chart was only for the limited purpose of showing that it initiated by the legislature, except in case of, as my lords have rightly said, my lord, Taiwan and Taiwan also not fully, but South Africa. And South Africa, I have mentioned, my lord, at page 43, my lord, that is 47, PDF 47. Justice gets, my lord.
Yes.
Possibly the only country subject to verification, but we tried our best to verify. South Africa is the only country where the process was first initiated by judiciary and then followed by.
Which is Furi's case. Furi, which
Yes.
was read out by Mr. Grover.
Yes, my lord. Then, my lord, countries where civil unions are legal. That also, my lord, we have given. But I'm not going one by one.
No, we'll just only look at the headings of the.
Yeah,
And if we
that's
come
right.
across any one of us
There
comes
are
across
some-
something interesting, we can pause
There are
there.
some mixed processes.
Yeah, my lord,
which indicate
for example, Bolivia is by judiciary.
Brazil,
Because, my lord,
India.
Second Constitutional Chamber of La Paz Department Court of Justice, citing advisory opinion number so-and-so, issued by the Inter-American Court of Human Rights, ruled in favor of the couple recognizing same-sex civil union. However, it may be noted that several bills had been introduced in the country's legislature seeking recognition, and the political debate was ongoing on the said issue.
Look at Latvia. Something very interesting happens in Latvia at item 9.
Yes, my lord. By judiciary first, thereafter legislature. Latvia does not recognize same-sex marriage, but same-sex couples are able to register their partnerships with the government through the courts. On 12th November 2020, the Constitutional Court of Latvia ruled that the Latvian constitution entitles same-sex couples to receive the benefits and protections afforded by Latvian law to married opposite-sex couples, and gave so-and-so until 1st June 22 to enact a law protecting same-sex couples. My lord, that may be, my lord, as per their constitution. My lord, your lordships never issue a writ to parliament.
A lot of countries, of course, we don't follow that model, Mr. Solicitor. I mean, we are now discussing at a theoretical level. Some countries have followed this doctrine where the judiciary say we give you 3 months to take steps to enact law, for instance, so 3 years or 1 year or whatever. If you don't, then this will follow. So Latvia seems to have followed that.
That, my lord, but that, my lord.
No, I began by saying that we have not, we scrupulously serve no mandate.
Your lordships have always, my lord,
to Parliament.
scrupulously, my lord, never issued writ.
There are countries which follow that,
Yes.
we declare the law, we give you so much time, put the law in order.
Depends upon the constitution. Like, my lord, in Great Britain, the parliament is completely sovereign. My lord, there is no power to declare the law unconstitutional, etc. My lord, that depends upon the constitutional culture, as I say, my lord. But our, my lord, constitutional position has been consistent, my lord.
Let's scroll down.
Then, my lord, summary is at page 49 PDF. Civil union position. Then countries where civil union or a partnership arrangement is given recognition, 16. Countries where recognition was through purely legislative process, 13. And country where process was mixed, 3. Number 98. Therefore, it is clear that societies and countries have acted only after the said concept has gained currency or acceptability in their respective jurisdictions, and the elected representatives have acted on the basis of locally prevailing ethos, beliefs, and understanding of marriage or civil unions. It is submitted that therefore there was a clear and direct democratic mandate behind the recognition of same-sex marriages in which ever jurisdiction such relationship were recognized.
Mr. Solicitor, if you don't mind, can we now just skip a little bit and go to page 54? Let's now go to the heart of the matter, which is the legislative intention behind this, because you've given us a flavor now. You've
Yes,
substantially
yes.
gone through your, isn't
Would
it?
your lordships, my lord, consider coming to page 50 instead?
Those judgments which say about legislative policy and other things.
Yes, my lord.
Those you've given them to us, and it's very well basic doctrine. I don't think we need to read it together. Prim
Your lordships,
grana
indeed.
and
My lord, the proposition is
and everything. Yes.
some of them are constitution bench judgments. My lord, that's all I wanted to highlight. And my lord, the purpose, as I pointed out yesterday, was that I'll quote the paras rather than burdening the volumes, my lord, so that your lordships can
Since,
immediately
Brother
get.
Call and Brother Bhatt are not here. I don't online. They're online. I think those judgments at page 50 to 54, we need not spend time going through them, right? This basic doctrine, so they're well known. So we can just maybe look at them and go to the real.
Legislative intention behind Special Marriage Act. And
I think yes, exactly. We'll go straight to page 54. I think.
Your lordship, sorry, my lord, page PDF page 54. My lord, the
Which is not to
purpose
say
is
that those judgments are not relevant, but there's just they're so basic that I don't think we need to spend time reading through them. That's all.
my lord, there are settled positions your lordships are fully aware of. This is just, my lord,
Let's
so that
see now how you've formulated at page 54 PDF.
yeah, my lord,
your legislation.
54, my lord, I'll just put, my lord, two propositions. Why, my lord, I am going through the debates. It might at some time, my lord, appear to be a little irrelevant, but please go through it. My lord, this is the debate when Special Marriage Act 1954 came to be enacted for two purposes. A, the intention was heterosexual, intra-faith, but heterosexual.
Just 1 second.
I'm sorry, interfaith, not interfaith, intercaste, but heterosexual.
Religious and irreligious, or no religious.
Yeah, yeah, yes.
It's only distinction between
Actually, it was
religion and
religion neutral.
correct.
The SMA was intended to be religion neutral.
Yes.
I would, my lord, nothing turns on that, but just academically, my lord.
Idea was because to create a platform where couples were not going to marry within the fold of their personal law.
The faith.
In that sense, religion neutral.
I'll just, my lord, just academically, nothing, my lord, may perhaps turn on this. Even if I accept that it's a secular law or a non-religious law, my lord, it has taken some concepts of uncodified Hindu law, for
Of course,
example,
it does prohibited relationship.
degrees of prohibited relationship. That is Sagotra and Sapinda relationship.
Absolutely.
But in the format of, my lord, a religious or a non-religious statute. Some concepts, my lord, are there. Degrees
The whole
of
object was to permit two couples, two individuals who profess different faiths to have a
two
provide-
different
to allow-
individuals of opposite sex.
That's what we are now considering. But the idea was basically it was to allow two people who did not profess the same religion to have.
Or maybe the same religion, but different castes.
Correct.
Correct, you're right.
Because section 21A, my lord,
That's why Arundhati referred to the caste disability
Yes,
Act
yes.
and other things.
Dr. Ambedkar piloted this bill, and this is before
the reason was, my lord, your lordships have been shown, my lord, by Ms. Kaju. Lord, it was earlier 1872 law, where if I marry under that Special Marriage Act, I have to denounce my religion. So therefore, my lord, that was brought back by 21A.
21.
Mr. Solicitor, you'll not be completing tomorrow, today. So tomorrow when you resume, maybe if one of your juniors can do a little exercise taking from the table which Ms. Kaju has prepared.
Yes, yes.
And give us a 2-page note or 3-page note on the antecedents of the SMA.
Yes, yes.
Just take, you'll get the materials from that note and just sort of develop it into a 2 or 3-page note for us tomorrow morning.
To some extent, my lord, I've set out some of the materials of the debates and so
Right.
on in the additional compilation which I had filed.
Do we have the statement of objection
Yes,
reasons?
we do. So which refers again to.
No, debates also mentions that. My lord, there is
All
a
right, let's
flavor
see that page
in the debate.
54.
Now, the
Page-
second point, my lord, your lordships may bear in mind. My lord, it was argued that in 1954 there was no concept of gays, etc. And therefore, obviously, there was no mention. Your Lordship, my Lord, that was Mr. Rodgi's submission. My Lord, my respectful submission, my Lord, and I'll take Your Lordship to that, are twofold. A, even if that is so, that is no ground for the court to rewrite and include something not intended. B, they were aware of it. There is a discussion on that. And therefore, I'm going to respectfully submit that there is a conscious omission. That's one more reason why it cannot be read into. Lord, may I read, my Lord,